from this case. Mr. Domina, good morning. Let's give everybody a minute to get in and out of the courtroom. That appears to have been accomplished. You may proceed.
May it please the court, I'm Dave Domina. I'm here on behalf of Bruce and Annette Wiles. Your honors, when a physician attends the birth of a human being and signs a birth certificate, the signing of the birth certificate does not create a life. The life has to have substance separate and apart from signing a piece of paper. When a lawyer creates a business corporation, the lawyer does not give that business entity substance that counts any more than a birth certificate without a person. The organization has to have substance or it doesn't count. In this case, the argument that was adopted as a form over substance victory by the district court was and is that a limited liability company without any existence except as papers executed and residing on a lawyer's shelf, without even as much as a bank account, should be treated as the true owner of a corporation that farms 5,000 acres of land that it owns, 5,000 acres of land that it leases, and conducts millions of dollars worth of business each year. My client wants his 31% investment out of that company. He wants out because he doesn't want to be in business with his brothers anymore. He believes he can establish grounds for liquidating the corporation. He is the beneficial owner of the corporation's stock. Each and every year, his brothers certify with him to the taxing authorities of the United States and this state that he and they are the beneficial owners of the corporation. They pass all of the income through the shelf entity that resides only in the lawyer's office to themselves. And when they do that, they certify that the persons at risk in the activity of the active company are the Homo sapiens who are before the court today, and not the shelf entity created by the lawyer into which life was never breathed by activity.
Mr. Domina, if the grounds that were alleged as grounds to dissolve the corporation had been alleged to dissolve the LLC, would they have been sufficient under the LLC statutes to dissolve the LLC?
Yes, we think so. That would mean we would go through the process of dissolving the LLC. The asset we would confront under the argument presented to you is corporate stock, and then we'd be back here, exactly where we are today.
It would be distributed.
It would be distributed. It would be distributed so that the status
and reissued.
Reissued, yes, but in the fractions that I assert to the persons who I contend are the beneficial owners, so that the circumstances down the road 3 or 4 years hence would be those I present to you today. You have persistently and consistently said for 140 years that when the issue before you is true ownership, you will not be controlled by form. You have construed deeds as mortgages when fraud was involved. You have set aside and ignored deeds when grounds to do so existed. You have disregarded corporations. You have ignored things that were legal fictions because they pulled a curtain over true ownership.
Going back to the sub 21 definition of the shareholder, is this undisputed that appellants' names are not on the shares of the corporation?
That is undisputed.
Okay. And is it undisputed that there's no nominee certificate on file with the corporation.
That is undisputed.
So we are moving on from those two possibilities of rendering the appellants shareholders and moving on to your argument. Is that correct?
Correct, Your Honor.
Okay.
Yes. And on that point, in addition to the point I made in response to your question a moment ago about being in this position again in 2 years, if we wrap it back, I would add this. If the argument is that a single sheet of paper that says Wiles Brothers Enterprises holds Bruce Wiles stock for him as nominee is the missing event, if that's what's really missing, and if Bruce Wiles can control that, we did it with a complaint, which was served on the corporation and is on file there. If we can't control it, which we think we can.
You're saying that should be equated to a nominee certificate?
Why not? We have
Well,
given notice.
That
We
was
have
my
gi-
question.
Okay, well, and
That's how it works here. I asked a question.
I endeavored to answer it rhetorically. I intended my why not to be an affirmative yes, and I apologize.
Okay, but that would be
it
your,
wasn't.
that would be your position, that nominee certificate may not be a word of art and it could be accomplished through some other pieces of paper. Is that a correct understanding?
That is a correct understanding.
Thank you.
There is no form prescribed, and I apologize
Okay.
again
No,
for
that's fine.
answering offhandedly. If, on the other hand, Bruce Wiles can't make that filing, and it seems illogical if you're to look at the literal language of the statute that he can, because he's not empowered by Wiles Enterprises LP to do that, and if the statute is to be taken at its face in all circumstances, then presumably Wiles Enterprises LP can do it. And if he only owns 31% and his problem that he can't get out because the same people control both companies, they have him trapped. And that's their position before you. The trial court understood that. The trial court also understood that it had to depart from the literal language of the statute to get where we want it to go. We want you to depart from the literal language of the statute where the circumstances make it clear that the literal language of the statute obfuscates true ownership. Because in addition to those items that are not contested about the nominee certificate, this information is not contested about Wiles Enterprises LP. It has no operating activity. It has never had any. It's never had a bank account. It has consistently been a pass-through corporation or entity, tax entity. That's important because our tax system depends on the taxpayer being the party at risk. If we allow the insertion or overlaying of a party without assets to somehow be a veneer between the person truly at risk and the tax-paying, tax-owing entity, and we disconnect the two, we disconnect thousands of ideas about piercing to get to the money
That
the
would
government
be,
needs.
that would be your test if you don't comply with the federal taxing statutes?
No, it would not, Your Honor. I think in this case it simplifies your inquiry. My test would be whether true ownership, using your historical language, is obfuscated by what is a legal fiction, a subterfuge. I offer tax as an explanation here because it's so obvious that each and every year the appellees have certified that my client and the individuals are the beneficial owners of this stock. We ask you to hold them to their words.
If there were no fraud involved, would there be grounds for a court of equity to go beyond the statute?
No.
So it's the alleged presence of fraud that's controlling in your argument.
I think so.
Thank you.
Thank you very much.
Thank you.